Good morning, Mr. Chiano.
Morning, Your Honor. If it pleases the Court, Your Honor, Frank Ciano, Your Honor, for the
Grandmother.
petitioner, and she is in the courtroom to the side. The grandmother, she was the petitioner in the guardianship and also the appellant herein. Also appearing with me is Rafaela Contratesi Hanley, who assisted me in the briefing along with her sister, Adriana. Your Honor, this is a case that we submit is a due process situation, or the lack thereof. The fourth child, who was born in December of '08, was ultimately removed from the family through a CMP entered in the Cambridge District Court, Cambridge Juvenile Court, and that was noted that that child, the fourth child, one of four, and the youngest, was removed, was noted in the lower court's finding at paragraph 109. I apologize, Your Honors, that you are not in possession of the juvenile court judge's findings and conclusions. We requested them, as you can see, at our Appendix 44, and we were only allowed to use them for me to look at and no one else to see. So then I reapplied and said, I've got an appeal, can I use it in the appeal? And finally, on 8/24, he allowed me to do that, but this brief came before you on 8/12.
Mr. Ciano?
Yes.
The motion, the issue before us is I think, purely the question of your 211-3 about the denial of your motion to intervene in this limited way, correct?
We briefed more.
But isn't
Your
that
Honor.
really what was before the single justice?
That's what was before the single justice in May, but then what happened is Judge Corbett then, pending that, and she made her decision on 6/30. On 6/23, he decided the whole case, and we appeared before him on 7/1, arguing various parts of it, along with being allowed to see the entire finding. And it was then that he threw our guardianship case out. We expected to be heard on our guardianship once he decided the CMP, and he dismissed it and made.
And that's on appeal to the appeals court, correct?
It is, Your Honor.
But let me get back to the intervention,
Yes, Judge.
if I could. And I appreciate that I think this is right, that the rules of civil procedure don't automatically apply in the juvenile court. But was your motion to intervene for this limited purpose, was it one that was as a matter of discretion or a matter of right? Did you argue, or did you argue it in that way at all?
Well, we had previously, we initially, Your Honor, filed on 3/1, and maybe it was a misnomer. On 3/1, we filed the petition for guardianship by the maternal grandmother for all three children, and at the same time we filed a motion for joinder, which was heard by Judge Corbett on 3/9, the motion for joinder, which is noted in our appendix of the guardianship. He heard it and took no action on it, and from 3/9, consistently through 310, 47, 527, and 7/1, he never took action on our motion for joinder until he dismissed the guardianship case. So what we were trying to do in May is, and we were consistently left out of the courtroom in these various juvenile proceedings, which started in July of '07, and the trial didn't begin until December of '08. But coming back to you, what we were basically doing, we heard through the grapevine what was happening, and we heard through the grapevine, not by notice or from the court telling us when we were supposed to come in, because we were never allowed in the courtroom, neither me nor my client.
So you filed this motion for joinder and also for guardianship, and you were heard when you first filed the motion, but did you ever attempt to have the judge rule on the motion?
That's what I was doing on 3/9, Your Honor.
Yeah, but you just gave me a whole bunch of dates.
Yes.
April, May,
Yes.
June. Did you ever go back and say, Judge, I'd like a ruling on this motion?
He never let me in the courtroom, Judge. And in fact, when my client was finally allowed to testify...
He never let you in the courtroom? You never went to the clerk's office and said, I'd like to be heard on my motion?
It's been continued. He's not going to take action on it. He'll do it I don't know when he was going to do it. So my understanding was that when he finished the CMP, that he'd bring us in on the guardianship, because by statute, we were entitled to a hearing. We never got one. So she testified on 422 before him at the request of the father's counsel for possible placement, and he wouldn't let me participate in it. So questions were asked of him, and I said, can I come in the courtroom, Judge? Because he never let me in through any of it, which is, some of the juvenile judges will let the lawyers in. This court, they don't, down in Brockton. So I said, can I be heard? No, you can just sit there. So they asked her questions, and she was done. I said, may I be heard? No, you may not. And that was the end of it. So we then heard that the fourth child was restored to the family, and I said, well, is anybody going to do a motion to tell the judge this while he's thinking about the case? Well, I don't know. So then I did it. And I was joined, with all due respect, by the counsel for the mother at appendix, and if I have this right.
Well, did counsel for the mother bring that fact out during the trial?
The trial ended on
No,
422.
that's not my question. Did counsel for the mother bring this fact out during the trial?
No. Not that they were restored, no. But it was brought out that the child was removed, and I don't know who told them, because we weren't at any of the proceedings, nor did we get any of the transcripts. We had to fight for the conclusions.
Mr. Ciano, am I correct in understanding that the judge has made that the judge, the juvenile court judge, has made several findings, entered several orders? One is that the mother is unfit.
Yes.
Second, that the department's adoption plan is in the best interests of the children.
Yes.
And third, that the mother's plan, that the grandmother, I take it the maternal grandmother, take the children, would not be in the best interests of the children.
That's what he found.
Okay. That is before the appeals court,
Yes,
correct? And so that we don't determine here, right?
You denied my request for direct appellate review in October, and I've got 9 minutes, Judge, of all this other stuff, which I wanted to talk about. But basically, I get the point, Your Honor, and I wondered if you'd let me argue, but
So here, what's the most important? You're here on a 211.3,
Yes,
okay? That is a very narrow statute. What's the most important relief that you believe is consistent with 211.3? I mean, why should these 6 justices who don't have the appellate record and so on, I mean, why should we be looking at, I mean, what is your claim here?
I was hoping, Your Honor, that you'd send this back to Judge Corbett, telling him to reopen it, take a look what happened, what Judge Tyree did, because why would she restore one child? Why are they fit for one? And why did they cooperate in that one?
Is that relief that the appeals court can give?
Of course, Your Honor, but that was part of our 211.3, and, time is of the essence, and under care and protection of Robert, it's the constitutionally protected right to family integrity, and he didn't consider what happened. Though he found that the child was removed, he didn't find, and it was after, my understanding is it was after he decided the case, or after he closed the trial, that the fourth child was reunited with the mother and father. And that's what we wanted to bring to his attention. The other issue, Your Honor, is this is different from Zeta, in which, in that case, a juvenile judge took prior proceedings into effect. But in this one, we submit that all he had to do under Howe versus Prokop, 21 Mass Appeals Court 919, is take a look at the docket entries, which showed that the fourth child was reunited. And the object is to bring the family together. At the very least, that's what I was hoping you'd do. I was hoping you'd reconsider your direct appellate review decision, but there you go.
Mr. Ciano, let me ask you this. You are aware, or I hope you are aware, that CPCS has filed an amicus letter in this case?
They didn't send me a copy of it.
Well,
No, I saw.
They show you as being CC'd.
Yes.
I don't.
It was dated December 31st, so it may not have.
So maybe, yes, it's always,
But let me
That's
ask
what
you,
must have happened.
may I ask you this? Is CPCS representing some of the parties here?
My understanding, Your Honor, is, yes, that there are appellate counsel that have been appointed for both mother and father. And I've spoken to several of them on the telephone. Yes, I spoke to this gentleman on the telephone, but I have not received this as yet. I went to my office
My question
early.
is whether this is an appropriate amicus for us to be accepting, because it appears to me that although technically they are not in the 211(3) appeal, they have very real interests at issue here, and that's typically an amicus has no interest in the outcome, in the specific outcome. Correct?
Yes, Your Honor.
Okay.
And also, Your Honor, at Appendix 42, the lawyer for the mother did note via letter that she was joining in this 211(3). And that, it's part of my appendix at 42. So I'm not surprised. I don't know what this says, but, and counsel also for, in the trial court, in the juvenile court, Tracy Galloway for the father, she's not appellate counsel, as I understand, but she came today also.
Thank you, Mr. Siana.
Thank you. I can't say anything else, Your Honor. Gotcha.
I
Thank you,
think
judges.
you've made a
Thank you.
very strong argument, Mr. Siana.